So first of all, by way of overview, there are two types of nuisance that constitute a tort and which can found the basis of a claim in the civil courts. Firstly, private nuisance, and secondly, public nuisance. And so it's important to be clear at all times about the difference between those, but also just to have in mind that the word nuisance is often used to describe other things, such as criminal offences. So there's a number of additional points to raise about public nuisance and the liability for it. A landowner may be held liable for public nuisance regardless of whether the nuisance is caused by their own activities. So if it's caused by a third party or even by natural causes, there can still be liability. The landowner has to be aware, however, of the nuisance and have the ability or the opportunity to abate it. The difference as well between public nuisance and private nuisance that's worth pointing out here is that there's no requirement to show the existence of and a breach of a duty of care. And it's not necessarily the case that you have to wait until there is a action which requires an injunction to get someone to stop doing it. In the Barking and Dagenham case against People Unknown, 2021 High Court decision, precautionary injunctions, as they're now known, the Latin has been dropped, is said to regulate or prohibit, should I say, conduct that hasn't yet occurred or hasn't yet been executed by a particular defendant. The courts have decided in the Ineos case from 2019 that where such a precautionary injunction is sought, the claimant must show that there is a real and imminent risk of harm.